Hello, my name is Courtney Ionelli, and I will be discussing the legal use of force along with the Fourth Amendment. The Fourth Amendment prohibits unreasonable searches and seizures. When police officers conduct searches and seizures of persons, places, or things, they generally require a warrant. Warrants are required to be issued by an impartial judge or magistrate, have probable cause, and particularly describe what persons, places, or things are to be searched or seized. If a search or seizure does not meet any of these requirements, then it violates the Fourth Amendment, and it's possible that any evidence obtained, or even the case itself, may be excluded at trial. Under United States law, there are two circumstances where officers are allowed to use deadly force. The first is in defense of life, whether it is to protect their own life or the life of another person. For example, if a suspect is aiming a gun or what looks like to be a gun at an officer or another person, then the officer can legally shoot the suspect if he believes that another life is in danger. The second circumstance is if the suspect is trying to escape, but only if the officer has a reason to think the suspect poses a significant violent threat to the community. For example, if a suspect is being pulled over for a traffic stop for failing to completely stop at a stop sign, which, keep in mind, this is a violation of a traffic law, and the suspect fails to pull over for the officer to investigate, the suspect is fleeing. Now the suspect and the officer are involved in a high-speed chase, and the suspect is running all red lights, stop signs, and violating numerous traffic rules. So this means he is endangering the lives of other citizens and the officer because he can seriously hurt or even kill someone during the pursuit. It is in violation of the Fourth Amendment if an officer uses deadly force for a suspect who is unarmed and nonviolent. In the 1985 case of Tennessee versus Garner, Edward Garner was shot dead by two police officers after he fled the scene of a house burglary. The officers tried to stop Garner from climbing a fence to get away when they killed him. He was 15 and was only found with $10 and a purse in his possession. So in a case where a suspect is stealing clothes from a Target store and gets caught by employees, they then call the police, and the suspect then decides to run from law enforcement. It is illegal for them to try to shoot at the suspect because this was not a violent crime, and the suspect is not putting anyone in danger by simply running away on foot without pointing a weapon at anyone or the police officers. In the 1989 case of Graham versus Connor, DeThorne Graham was having a diabetic attack when he went to buy an orange juice from a convenience store. He quickly left when he realized how long the line was. A nearby officer suspected that Graham was robbing the store when he noticed his quick exit, so he slammed him against the hood of his police car. He then broke Graham's foot. The court ruled that officers do not have to demonstrate that their intentions were good, but rather that their actions were objectively reasonable, given their point of view of the situation. In an example relating to the Graham versus Connor case, an officer is allowed to use force on a person who is walking down the road after they get a call of a nearby robbery. If the person matches the description given of the suspect, then this gives them probable cause. In this case, it is objectively reasonable for an officer to believe this may be the suspect who just committed the robbery because of their perception of the person. This officer could use force by aggressively apprehending the person. This is a necessary circumstance that may be allowed in order for the officer to investigate further. There is no reasonable standard to know when lethal force is needed. It all depends on an officer's perception. So in the apprehension by the use of deadly force is a seizure subject to the Fourth Amendment's reasonableness requirement. To determine whether such a seizure is reasonable, the extent of the intrusion on the suspect's rights under that amendment must be balanced against the governmental interests in effective law enforcement. This balancing process demonstrates that, notwithstanding probable cause to seize a suspect, an officer may not always do so by killing him. The use of deadly force to prevent the escape of all felony suspects, whatever the circumstances, is constitutionally unreasonable. Thank you.